talk about this Supreme Court because it is always fun. It's a great parlor game to talk about the Supreme Court. Anthony Kennedy steps down shortly after the last case is released, and I can't believe I'm the only one who has said this, or I'm the only one who have heard say this. And of all the people freaking out over this, this was Judge Bork's seat.
Yes.
Right. And so when Kennedy blocked Bork for whatever reasons, then Ronald Reagan went to Kennedy.
Yes. Robert Bork was, it's now in the Oxford English Dictionary, it's now a verb, to be borked.
Right.
So Bork went down, was not confirmed. President Reagan nominated Douglas Ginsburg.
Oh, the pot smoker.
And it turns out that he smoked a little weed, and that in 1980.
Forgot about that.
Yeah, and if you remember, that disqualified him within 2 or 3 days.
Yes.
And so, third time was a charm for President Reagan. He nominated Anthony Kennedy, and who in this day and age can even fathom? The vote was 97-0.
Yeah, interesting.
To confirm Anthony Kennedy, McGraw.
If Bork would have been seated, he died in 2012. Now, I know you don't know if he would have stayed to the end or whatever else, but you could argue that it would have been Obama's pick if Bork would have gotten on.
Right. And we never would have had the Merrick Garland drama
Right.
and Mitch McConnell abolishing the filibuster.
So the tea leaves, the dominoes that had to fall to get us to this position to have a president name 2 Supreme Court justices in the first 2 years, which is going to reshape the court, which might put into play Roe versus Wade, is a moment in time that is extraordinary.
Extraordinary, and probably, I think in that context, McGraw, it's unprecedented.
Yeah.
We've never seen sort of a confluence of events that constitutionally bring us to where we find ourselves on a Friday morning.
Democrats virtually helpless, right?
As a practical matter, they probably are. And I think a couple of points, McGraw. Let's just set for our listeners the basic table. The president has the power to nominate Supreme Court justices, and the Senate has what's called advice and consent power, and they confirm. So the nominee that President Trump's going to name in the next few days, he or she will be subject to confirmation by the Senate. It used to take 60 because there was a possibility of a filibuster, but the Republican blew up the filibuster.
Now there is no.
With Gorsuch, so there is none. So right now it's 51-49, but with Senator McCain's illness, it practically is 50-49. So there will be a tremendous political battle on 2 levels. One will be as to the senators themselves. And that will be as to Senators Murkowski and Collins in particular, to see if they can be persuaded to reject the nominee on a Roe v. Wade issue. And then conversely, there's going to be tremendous pressure on senators who are up, Democratic senators like Claire McCaskill, who are up for re-election this fall in so-called red states, to get them to support the president's nominee. The second category, and the one that I think is so unfortunate, and we can talk later as to the impacts, it's already started. The borking of the nominee has already started. Not disagreement and not commentary. I'm talking venom and vitriol, the likes of which we have never seen. And we've seen a lot, McGraw, with Bork, with Justice Thomas's nomination. It's already started. And I think there is a significant part of the opposition that can read the tea leaves, can count the votes and say, we don't have the votes to stop Mitch McConnell and the Republicans.
Right.
We need to destroy the nominee, destroy his or her reputation. Whatever we can do to pillory them, we're going to do it.
Yeah. Now, with the 50-vote threshold as opposed to the 60-vote threshold, Donald Trump and the Republicans, he can elect a more conservative judge because he doesn't have to worry about the 60 votes. He only has to worry about the 50 votes. So in a sense, right, he doesn't have to pick, a more nuanced, sort of middle-of-the-road, lean right person, right? He doesn't have to throw a bone to the middle. He can go as right as he wants because he only has to get the 50 votes.
Very, very well put. And I think it's an abject lesson in just what you pointed out, McGraw, and that is when you lower the threshold,
right,
then inevitably you risk moving the consensus needle in the Senate. If you need 60 votes, by definition, that's 60 United States senators that you have to come up with a consensus candidate. If it's only 50, particularly if they're all from your party,
right,
as we would say in the country, that ain't consensus territory.
Well, and that's why it's an embarrassment of riches for the conservative movement because, right, I mean, this is a moment in time, but be careful, what's good for the goose is good for the gander, because at some point, the Democrats are going to have control of the Senate, and at some point, there's going to be a Democratic person in the White House, and then you're going to be able to nominate the most liberal judge out there.
Well, you're exactly right. And what's sauce for the goose is sauce for the gander. And what the Republicans in the Senate would say is, hey, we didn't start this filibuster destruction path.
Right.
Harry Reid in 2012,
right,
he began to change the rules. We just made one little add-on at the end with Supreme Court nominees.
Where are you with the overturning of Roe versus Wade? There are some people, court watchers, who say this is a real possibility, and it's a real possibility within the next year to 18 months.
Until this week, McGraw, I would have said it's highly unlikely that Roe v. Wade would be overturned because I think a substantial number of observers see it as what is referred to as settled law. You may not agree with what Justice Blackmun wrote in 1973 and when he found the right of privacy in the Fourth Amendment, but we've now had it as the law of the land, the baseline constitutional interpretation for now 5 decades.
Right.
And in that respect, I think significant numbers say it's settled law until this week. And this week, McGraw, in the Janice decision, which was the union dues decision,
right,
the Supreme Court overturned a 41-year precedent that I think most people had thought was settled law.
Right.
And they overturned it. And so if among our listeners are groups of listeners who are worried about a Trump appointee to the Supreme Court substituting his or her vote for Justice Kennedy's 5th vote, which historically has upheld Roe v. Wade, that new nominee, the new appointee, would go the other way and revisit Roe. I think our listeners' concern have been heightened by what happened with Janice.
I think that your settled law argument is a bunch of hooey, because whether the court, and you're a much more learned person than I am on all this, but you say settled law because it's nice, but we've seen settled law overturned quite a bit over the last 10 years.
Well, no, I guess I would take issue with that, McGraw. I think at the core of our system, our judicial system, is this notion of stare decisis and reliance on precedent. And whether you're a trial court judge here in St. Louis County or...
But how many times has precedent been overturned by the Supreme Court?
Very rarely.
Well, you had this one.
Well, you had Corey Motz. Wait, here are the notorious ones.
Okay.
Plessy versus Ferguson.
Okay, which we could argue that that's a good one.
Right, but Plessy versus Ferguson was overturned by Brown versus Board of Education in 1954. And you had in the 1960s, you had a lot of the First Amendment rights in terms of Miranda and Gideon, the right to counsel, and those overturned a lot of individual freedom, individual rights cases. But, for example, the Corey Matsu case, the internment case in 1942, it had stood on the books until this week.
Right.
And it was ceremoniously overturned in the travel ban case.
I guess what I'm saying, and I don't mean to cut you off because I'm short on time. What I mean to say is the justices will argue settled law when it's beneficial to them, and when they want to overturn settled law, they have no problem doing it. No one's ever. How many people have said, "Boy, I disagree with this, but it's settled law, so therefore I'm going to stay with an opinion that I disagree with, but it's settled law"?
I would agree and disagree, and I'll take the disagree part. I think the quickness, the speed with which a Supreme Court overturned settled law is very, very slow and very, very deliberate. There have been justices that disagreed with the Abood union dues decision in 1977. They have disagreed with it and dissented over the years, but it was settled law until this week, and the court, by a 5-4 vote, said, in effect, we made a mistake. But it took them 41 years, and that's why I say, McGraw, we've had Roe v. Wade on the books since 1973. Whether one agrees or disagrees with it, it has been the settled law, and I think, in light of what happened to Janice, I think there are those who need to take note that it may change with this new appointee.
Greg Willard, ladies and gentlemen, that's who I would nominate as an opening for the Supreme Court, but that's just me. Professor at St. Louis University Law School, KTRS Legal Analyst, friend of the show. Thank you, sir.